Okay, I think we're live.
You're live. Hello, everybody.
Hi, all.
Hey.
My name's Aaron Hall. I'm here with Rylan Warner, Jennifer Howard, and Zach New, and we are here to give some updates today, and then get into any questions that you have, either about the updates, anything else, any of the ongoing litigation that you wanted to talk about. We'll try to get through all the questions we can. So to start it out, why don't we go to Rylan for our first update?
Sure. Yeah. So I wanted to talk about a new presidential proclamation by President Biden. The entire purpose of it was to revoke a previous proclamation issued by President Trump. This proclamation, it was 9945, which Trump put out in October of 2019. And it was saying that for anyone applying for immigrant visas, they needed to demonstrate that they will be covered by an approved health insurance within 30 days of entry into the United States, or that they would be able to pay for reasonably foreseeable medical costs, which in the United States, medical costs can be completely unreasonable and unforeseeable. But this was very quickly sprung upon by immigrant advocates like Ayla in lawsuits. And so there was immediately an injunction preventing this from ever actually going into effect. But the Proclamation Act still was sitting on the record and sitting active. So President Biden went in and he said, you know what, we're going to get rid of that proclamation entirely. So there's no threat of it ever returning, at least not during his presidency. So it's a really good thing. It's just another kind of worry off of people applying for immigration, a worry off of their shoulders that they don't have to think about, oh, do I need health insurance? Well, I need to be financially prepared for foreseeable medical costs. And it's a nice relief for everyone out there.
So one of the questions I have about this is, I believe, and you guys can correct me if I'm wrong, but I believe that this was the proclamation that we had a good injunction and then actually a really bad Ninth Circuit decision in Doe. And but the mandate hadn't issued in the decision, and there was a lot of pressure on the Biden administration to get rid of this, and so that the case could be dismissed without mandate issuing and without that bad decision becoming a precedent. Because that decision, that Doe case, actually very much complicated some of our litigation in the Northern District of California, like in Enunciado, because the decision from the Ninth Circuit basically said that they would not throw out the proclamation in its entirety because of a distinction between domestic reasons for the use of Section 212F versus foreign relations reasons. And so I have not had the chance to research this, whether that mandate issued and whether this is going to mean that the Doe case does not become precedent, but I hope that that's the case. Anyway, point being that this, I think, has implications beyond whether the proclamation itself has been rescinded and whether the healthcare mandate will be in place. Zach, you want to go into your?
Sure. Yeah. So I don't really have a breaking news update type thing. More of a sneak peek for something to come from Josephine Hall. We're going to be doing another kind of more in-depth Facebook Live on a specific program. It's the International Entrepreneurial Parole Program. It was put in place in 2017, and then almost immediately, the Department of Homeland Security under the Trump administration said, hey, we're going to get rid of this. It's basically there's a specific visa for, I guess, investors from certain countries that we have treaties with to come and create businesses that are going to create jobs that are going to be invested in substantially. And this is kind of like that, but not I guess, exactly like that. It's a parole program that lets you, I guess, come in and start your business if you have this great idea, if you have this business that you want to start in the United States and I guess don't have the visa or availability to get here, but you have the capital ready to go. You have people ready to invest, and you would have your business up and running, but for the fact that you can't get here. Anyways, very recently, Department of Homeland Security is reinstating this program. they're putting out as much I guess publicity on it as they can. I was on a call recently where they said that they've gotten 30 applications total for this program. So they're trying to push this now, and we're going to be talking about it a little bit more in depth a little bit later on. Should be Jeff, myself, and Ryland, I think.
Yeah, I'll be there too.
So stay tuned on that. Kind of a new program that'll allow new businesses to open up for people who maybe wouldn't qualify for an E2 because we maybe don't have a treaty with your country or something like that.
That's awesome news. Jennifer?
Sure. So this is kind of breaking news, I guess. So 2 days ago on the 18th, the U.S. Department of State announced that they were changing their policy regarding birthright citizenship. So now, if a couple abroad is married and they have, it says either a genetic or gestational tie, and one of them is a U.S. citizen, then their child born abroad can gain citizenship through them. And this comes after there were a couple of cases in, I believe, 2019 and 2020, where gay couples were denied U.S. citizenship for their children, denied passports, because they said, they use like in vitro fertilization or surrogacy or some other form of assisted reproductive technology, and it didn't count for birthright citizenship. So this announcement, this policy changes that and will allow couples who have, had a child, a non-traditional way to gain U.S. citizenship for their children, and that applies to people who were previously denied as well. So it's really big news for a lot of people. And that's it.
Good. I think that's it for our quick updates. Now we want to make sure we can get to your questions. So, Rylan, you want to start queuing them up?
Sure. So we have a question from Alexander Popov. He says, Moscow accepted K1s. Do you think they can process DVs after judge's order? Separately, are online views really possible or just wishful thinking?
I can take this one, Alexander. It was really interesting. I think it was yesterday when we learned that Moscow had scheduled a number of K1s for June because their website does not say that that's possible. Their website basically says that they are shut down for the processing of both immigrant visas and non-immigrant visas, with maybe some exceptions for emergencies or age outs. But basically they say, we don't have the staff to be able to process other visas, and it's not possible. And they don't really leave any wiggle room there. And so when a number of people got scheduled shortly after we filed the Moscow K1 case, that was a very, very pleasant surprise. But honestly, at least for me, it was unexpected that they did that. And so the question of, well, if they can do that, can they also process diversity visa applicants? Yeah, I mean, why not? And the question is, can they do that after a judge's order? Yeah, I think they could. What I would envision a judge's order on this saying on the DV case, so this is for Go v. Blinken, I would envision it telling the Department of State to adjudicate cases even at the consulate in Moscow, but probably the judge doesn't care how they do it. So the judge could say, use your existing staff to process the cases, and if that's not possible, facilitate transfers to other consulates who can handle it in a prompt manner and do it all quickly. And so I don't think the judge would care, who did it, as long as they could get it done. And I think that's what I envision the order would say. The next part of the question is about whether online interviews are possible at the consulate, or is that just wishful thinking? I haven't personally delved into this research, and I don't know whether any of the rest of you have, but Greg Siskin has, and he spent a lot of time getting into this. And his conclusion was that, yes, it would be possible for them right now under existing law and regulations to institute online interviews. And so I know Greg's brilliant, so I trust his conclusion, even though I haven't done that research myself. And I would just say it's just part of the it's just part of the solution-oriented thinking that we need from people at the Department of State. They need to get creative. This backlog is out of control, and they need to figure out a way to make it happen. And so whether online interviews are part of that, it seems like that would be a good idea, but there are other options that they would have to make sure that they can start getting visas processed.
New question from Helen. She asks, can we explain and clarify what the motion to dismiss in Milligan means? And when and what updates or news are the remaining plaintiffs without interviews likely to expect? As someone that has been putting some work into the motion to dismiss on Milligan, I can address this at least partially. So the motion to dismiss, a big part of their argument is that what we were claiming is now moot. So what that means is the government, when we first applied for this lawsuit, was not processing K-1 visas for fiancés. And since then, the government has changed their policy and has made K-1 visas a national interest exception to the proclamations, meaning that the government is saying, hey, yes, we agree that we used to be doing this, but we're no longer doing this. So you guys don't have any claims to try to bring a lawsuit against us anymore. So we are going to have a motion to dismiss to get rid of this lawsuit entirely because your claims are now moot, is what everything I just said was referring to, mootness. And so we are still going to argue, although you have changed your policy a bit, it is still applicable to K-1s and still confusing. And there's the possibility that we could still, our plaintiffs could still be subjected to visa limitations, and the guidance could be changed at any time. So our claims are not moot. And additionally, our plaintiffs are still waiting for their visas to be adjudicated. So the problems that we sued over in the beginning are still existing. So we're going to try to continue forward on those existing claims. Zach, is there anything that you wanted to add to that?
Yeah, so I think if you really think about Milligan, it's two parts, right? The first part was there's these proclamations, and because of these proclamations, consulates are not processing K-1 visas. And the state is now processing K-1 visas pursuant to an announcement saying, okay, they're all granted NIEs. That's one part of the motion to dismiss, where they're saying, hey, we've granted this NIE kind of across the board, so this part of the lawsuit is no longer live. No, it's moot now. Our argument is, hey, like Ryan was saying, these things are changing basically by the day. We've been seeing, new announcements come out left and right. So it's what's called capable of repetition yet evading review. So it's not moot because the case could, suddenly change as soon as the dismiss would be granted, for example. We could suddenly see a new guidance come out saying K-1s are no longer given NIEs. So on that part of it, that's one, I guess, side of the motion to dismiss. The other side of Milligan and the other side of the motion to dismiss is the actual mandamus claims that we've been making, saying, hey, there's been an unreasonable delay for all of our plaintiffs in actually getting their visas. And that's where, I guess, a little bit more of the meat of the motion to dismiss comes into play. That's where they're making the argument of the track factors, if you recall from the preliminary injunction, where we go over basically, is the government operating under a rule of reason? Did Congress say that they have to conclude cases in a certain period of time? What are the kind of humanitarian factors at play here? Is the government acting in bad faith? All of these things that we have to argue. So it's I guess really diving more in depth into actually the merits of the case now. If you have been keeping up with the updates, I guess that's how we've been describing it, rather than kind of the informal process that we've been going through for the last, 9 months. We're now at the point where we're just going in front of the judge and litigating the case. So we have the one part where it's, hey, the proclamations, could still come back and bite our plaintiffs in the butt. And then we have the other part saying, all of our plaintiffs do still have their cases unreasonably delayed. So that's, I guess, broadly speaking, how the motion to dismiss is going, and I guess where the arguments kind of settle on both sides, if that makes sense.
Oops. And so there's a follow-up question from Maisie. What happens if Milligan is dismissed? Will the remaining plaintiffs get interviews or not?
So I guess that remains to be seen. And if Milligan's dismissed, that doesn't mean that everybody's claims are just everybody's cases are kind of like thrown back into the pool with everybody else. I guess we'd have to reevaluate what to do from that point. It's still months away before we would have any sort of decision on this, and in the meantime, people are still going to be having their cases mooted out and interviews granted and all of that. So I suppose I don't want to jump the gun and say any sort of strategy before it's been decided as a whole by the litigation team, but I'd say don't worry too much about that.
Helen asks, do you see any positives or negatives to Milligan round 3 by London K1 mandamus being filed?
I suppose the only negative would be that if both are highly successful and are pushing forward, and the judge in both cases say, yep, mandamus goes forward, unreasonable delay, there's just fewer interview slots. That could be the only real negative I'd see there. As far as positives, I think it pushes the consulate to actually prioritize these cases a little bit better, maybe schedule them more frequently, be more efficient with their interviewing, perhaps change some policies like we were talking about at the beginning to allow video interviews or something along those lines. I think that there's only positives with pushing the government more to have a plan and to start taking action on this backlog. And the negatives would just be if the government does not actually implement any sort of plan, we could just have fewer interview slots available for the folks in these mandamuses.
Okay. And from Mena, we have any timeline for Cairo spouse lawsuit after the government will assign an attorney. So I'm the one working on Abdel Wahid, the Cairo spouse's lawsuit. And again, I don't have any update as to if there has been a government attorney assigned. For a possible timeline following this, once an attorney is assigned, would one of you guys be able to, as you've worked on these cases more, give me a prediction for what that timeline would look like?
Sure, if nobody else wants to, I can just be talking the whole time. So how these cases go is that from the time that the complaint is served on the government, they have 60 days to respond. During that time, there's informal communications and there's mooting out of plaintiffs by having them get interviews and things like that. But on day 60, they respond to our complaint, and that can be with an answer or that could be with a motion to dismiss. After that, we actually kind of enter the real stages of litigation. So very shortly after, we would confer with the government and kind of figure out timelines on when various things would need to be produced. Like if you wanted to get internal Department of State documents, we would say, okay, hey, in 3 weeks, in 2 weeks, you need to produce the certified administrative record. And then after that, we would have 2 weeks, 3 weeks, 30 days to file our motion for summary judgment or something along those lines. Really, the specific timeline depends on that initial scheduling conference where we talk with the other attorney and then eventually the judge to figure out a timeline of how the case moves forward. But in the immediate future, it's 60 days from the time that the complaint was served for the government to respond to us.
Okay. Any news concerning Penn v. Blinken, the Brazil case?
So I'm handling that one, and no, we are waiting on a government attorney to be assigned, and then it'll kind of go the same way as Cairo, as Rylan and Zach just explained.
Okay. From Kimiya, what are the next steps in Kinsley? When will there be a judgment?
Sorry, I'm talking the whole time, but this is
Typical.
I filibuster these. This is the only reason we schedule, so that I can get my fix of talking. So next steps is we're going to add India as one of the proclamations. So we have to amend the complaint to say, not only are all these other 6 proclamations being challenged, but also the India proclamation that came out at the end of April. That should be today, probably, that's filed. And then about 2 weeks out, we'll file our motion for summary judgment. At that point, there's going to be briefing back and forth, and then the judge will set a hearing, and we'll go from there, I suppose. In the meantime, people are getting scheduled for interviews. I've seen a lot of people get their visas issued. Please do the update form if you do have any updates on your case. But yeah, we're seeing a lot of good movement, and in the meantime, everything's getting drafted, and we should have some filings in place in the next couple weeks.
From Hayes, what is the mandamus lawsuit for London going to cost for people who wish to join the lawsuit? And when will people be able to join the potential lawsuit?
So I know that that the part of the team that's doing the onboarding is hard at work on getting the FAQ finalized, getting the onboarding page finalized. I actually just saw an email that they are hoping to have it finalized and live either tonight or tomorrow. So that's the answer to when. As far as the cost, I think that they have a good idea, but I don't want to get out ahead of it and say something that's not right just because I haven't seen the final versions of it. So that will all be included in the information that we will get out there, likely either tonight or tomorrow.
Okay, from Ellie. She knows it's not a guarantee, but in our best opinion, is she likely to see a benefit from joining the London mandamus if she's only more recently received her NOA 2?
Yeah, so I am going to unfortunately just do the same thing and let her know that she should wait to see the FAQ. Sometimes we actually end up putting in like a date certain where potential plaintiffs have to have gotten their approval notice for their, in this case, I-129F from USCIS before a certain date in order to join, so that we think that all of the claims are sufficiently ripe for unreasonable delay / mandamus. And then sometimes the decision is made that it's not necessary. I just want to, again, not get out ahead of the FAQ and say that that information will be available shortly.
Yeah, and there's, I guess, like kind of competing views on that as well. Just to add on to what Aaron's saying, I mean, really, when we're suing over these mandamus claims, we're saying that your case has been unreasonably delayed. When you're a part of a bigger group, I guess there's less scrutiny of the initial, your individual, I guess, case at first. But at a certain point, we do have to show that your case has been unreasonably delayed. When there's a consulate such as like Manila that's just not processing K1s altogether, it's a lot easier for us to say, hey, this case is unreasonably delayed because they're not processing at all. And in other situations, it's a lot more prudent to have more time between your approval to the time that you would be asking basically to jump ahead.
Victor is a Go plaintiff, and he received the form to provide details about the principal applicant and the case number, but then he saw comments from other plaintiffs about an Excel file. Is there an Excel file where he can see his name, or did he get it wrong?
No, you got it right. The form that you completed actually populates an Excel file for us. And then we clean that up and use that in our communications with the government. So there is an Excel file. It's not accessible to plaintiffs. It's something that we have. And having completed the form and submitted it, you've done what you needed to do. So thank you.
If Kimiya again, knowing that the European Union is opening its borders in June to vaccinated American citizens and residents, Do you think that there will be a reciprocity for vaccinated EU citizens, residents who have applied to an NIV?
Well, there should be. I mean, it's a really good question, and I don't have a good sense of it. There's been so many things over the course of the last year that our government, in both this administration and the last, has done that don't make sense to me as far as justified by COVID concerns. And so I don't want to predict that our government's necessarily going to be reasonable and institute something like that, but they certainly should. And I don't know if have any of you heard rumblings of a reciprocity like that, or do you want to step out on a limb and make predictions?
My prediction is that no. I mean, the Biden administration has been all about, hey, we're going to listen to scientists, we're going to, follow the science. But I mean, just based off of these travel bans, we can see that that's not necessarily the case with, I guess, international travel. So, yeah, my prediction is that there's not going to be good science followed here.
So this is just from Abadir asking, if there is a motion to dismiss a mandamus lawsuit, how long will it be until a judge makes a decision on that motion to dismiss?
Once you're a federal judge, you're untouchable, which means there are no deadlines. You can do things when you can. And to be fair, the judges that have our cases are extremely busy. They have lots of cases before them, but the answer is we don't know. They don't have a deadline. There's nothing that says they have to decide within a few weeks of the briefing or the hearing or anything like that on the motion to dismiss. They could decide shortly thereafter. It could linger for months.
And I guess on the question of can the government dismiss a mandamus lawsuit, it's kind of like, at the beginning of a lawsuit, we can jump right in and say, a motion for summary judgment, we deserve to win right away. The government can kind of do that the same way with a motion to dismiss and say, hey, they don't even have a case here. Let's dispose of it. We win right away. So it's kind of the same thing that we would be able to do. Timelines are pretty similar. And yeah, it's hard to predict just because of caseloads for these judges. There's been no new judges, no like large scale new judges created since 1990, and caseloads have only increased since then. So yeah, judges are only getting busier. Lobby your congressman.
From Mike, he's saying how crazy it is that once the Moscow lawsuit hit, some of them got interviews, and Manila hasn't done hardly anything. Can we use this action by Moscow in the Manila case?
I do think that's an interesting point that we could put into a paragraph saying, hey, this is a country that had literally diplomatic relations shut down, and they're able to process what's going on with Manila. As we were, other people were talking, I just scrolled through the update form for the Manila case, and I saw that this is just me ballparking based off of, scrolling through an Excel sheet quickly. About a third of people, it seems like, who have filled out the update form have had their cases transferred. A handful have had interviews scheduled, and a handful have had interviews completed. So, even though the Manila case hasn't, I guess, fully moved forward, and we haven't had large-scale interviews, people are getting scheduled and cases are moving, even as we're waiting for the government to respond.
For the London mandamus case, if we had to guess, when do we think, if it goes forward and is successful, is it unreasonable to think or hope to be in the United States before the end of the year?
I mean, we're seeing people who are in Kinsley, for example, or for Milligan, who are getting their interviews in June. So I don't know. I don't want to make a wild prediction, but it seems like they have the capacity, if they need to get some interviews scheduled. And I would like to think that if a judge said you have to order, or you have to have these interviews and you have to issue these visas, they would do it before the end of the year.
I agree. I would just say it also partly depends on other factors particular to somebody's case, because I think Ellie, if I remember right, was the same person who asked if they it would be a good idea to join if they just got their I-129F approval notice. And I didn't really have an answer to that yet, but I would say that, if that's your situation and the rest of the plaintiffs and a lot of other people at the consulate have been waiting for longer, it may be that your case takes longer than theirs, because they're still going to be doing it in some kind of order, at least in theory. The actual order through which people are scheduled for interviews is pretty opaque, but I would just say it depends on the individual timing, the individual circumstances of particular plaintiffs, as well as the outcome of the case.
Isabella is asking if there's any news on the Cairo spouse lawsuit. I kind of answered this earlier, but I just want to give a little bit of a reminder that we're still waiting for the U.S. attorney to be assigned to the case, so there really hasn't been much of an update, but we will let you guys know when progress starts to be made there. Hopefully it's soon. Jamie asks, any movement, grumblings, rumors, thoughts, etc. on the K1 Manila mandamus?
All right, so I said that just a few minutes ago, but just to, I guess, reiterate, I quickly just scrolled through the update form. I mean, we don't have a U.S. attorney even assigned here yet, so, we're still in this waiting period, but cases are moving. Just by scrolling through and eyeballing it, it looked like about a third of people who had filled out the update form and had their cases transferred. And we do have a handful of interviews who have been scheduled and a handful of interviews completed. So things are moving, just perhaps not as quickly as we would like.
And Isabella asking about when is the last time I called to inquire about the case. And I called last week. I'm going to be calling again this week. So even though it's been 30 days since they were served, I'm keeping on top of it and just trying to see who's it's been assigned to. I've been reaching out to them.
And I'll just say that, while it's good to have the attorney assigned so that we can have some preliminary communications, that's best for all parties, I think. The fact that they haven't assigned an attorney doesn't toll their deadline for response. They still have to respond within 60 days of the service. So it's not delaying the merits of the case, the fact that they have not assigned an attorney or entered an appearance.
And also standard practice, for most cases that aren't these, I guess, kind of unique large-scale mandamus type cases, is that they will enter on day 59. So nothing unusual that they don't have somebody assigned yet.
Cecilia, we have a little success story here. She had a Zoom consultation with us, and her NIE was accepted, and she got her interview with the Consulate of Naples in April, and she got her visa.
That's awesome, Cecilia. Congrats.
Yeah, congrats.
Congratulations. Send us wedding pictures.
Yeah, are you here yet? Hopefully you're already here. If not, hopefully you're coming in soon.
Yeah. We love hearing the success stories as well. Alex asks, if a plaintiff gets interviewed and a consular would be biased and would unfairly deny visa granting, is there a way to question their decision in court or administrative proceedings with our help?
It's a good question. The short answer is no. The longer answer is maybe. So it's very hard to challenge particular decisions on particular visa applications in court. There's a doctrine that's called the doctrine of consular non-reviewability. And basically most consular decisions by officers on individual cases are sheltered from judicial review. There are administrative ways possibly that it can be addressed. Oftentimes where there's a wrongful visa denial, we are contacting the consulate for our clients in the days that follow, while hopefully the file is basically still in the officer's desk, explaining why they're wrong and asking them to reverse the decision immediately. And occasionally there are good results with that. If not, then if it's a legal determination, then there's a service called LegalNet that can sometimes sometimes result in them reversing course. That takes time. But there are things that can be done. Usually, it's not through a lawsuit.
Unless there's some sort of constitutional violation. I guess that's the only exception there. If there's some sort of like, I don't know, they came out and said, because you're a Catholic, I'm not going to give you this visa or something like that. That's like the very, very narrow exception where you're able to get around constant non-reviewability.
From Joey, he's asking if we think Biden's visit to the UK in June could lead to the USA opening its borders to British citizens. If not, then when do we think it'll happen? The delayed applications hurt, but not being able to see loved ones at all hurts more. I feel that. Zach was saying earlier we were trying to predict whether the presidential administration will open the borders to European citizens, because Europe has announced that it's going to open the borders to vaccinated Americans. And I agree with Zach's perception on it, that even though the science is maybe aiding our cause, that we should be opening borders a bit more, that it seems unlikely with the proclamation still in place. So it's hard to say definitively, but we're just keeping our fingers crossed that maybe something does happen. Okay. Let's see. In our opinions, do we think the remaining Milligan plaintiffs will get their interviews? And if so, any idea on when we are likely to hear back?
I mean, yes, in my opinion, but it's hard to tell when. I mean, a lot of it's up to consular capacity and where you're at. If you're in a consulate that has a very low caseload right now, then much more likely to get a case scheduled quickly. If you're in, I don't know, Paris, for example, it's super backlogged. It could be some time. Though I did hear from somebody who said that when they went to the interview, the Paris consulate said that they feel they could get through their backlog in about a month. So perhaps good news for other consulates as well, that they have something in the works to get through these massive backlogs.
This is a question about the Penn case. How do we feel about Judge Kelly? Does anybody have any previous experience with this judge?
No, I think that Chuck has. I mean, we have no negative opinions about any of the judges that we've gotten, and that's not just because it is a taboo question. We don't want to put it out there on the internet. It's really none of the judges are bad that we've gotten. So yeah, we have no negative thoughts whatsoever.
Okay. Waiting for London came on at NBC since July 20th. My fiance is 68. Can that help speed things up? The age of the plaintiff.
I mean, normally when they're looking at expedite requests, which is basically what this question is about, they really want to see that there's some kind of emergency, whether it's medical or otherwise, or that there's an age out question. And an age out question is a child who's going to turn 21 and not be able to immigrate on their visa if they don't expedite the case. And so the fiance's age of 68 in and of itself, in my opinion, is not going to help speed things up. If there are other issues present, medical issues or other issues, then possibly.
And then our final question comes from Tondi. So she's a Kinsley K1 London. She's looking to join the London mandamus, but she's concerned about joining as she's seen there's still Milligan K1s that have not been reached out to and had interviews set up yet. If these people haven't been scheduled yet and are being ignored by the embassy, why would the London mandamus help get interviews?
So, all right, I'll take it, I guess. So, everybody's kind of got their own specific circumstances, as we were talking about earlier. Like if you got your NOA2 in February, it's going to be perhaps a little bit longer of a wait than somebody who has been waiting since July, like our previous question moved up to the top. So it's case specific. There could be some folks that are waiting for interviews that really they just barely were approved. I'm not sure if that's the case. It could be that it's just the consulate capacity right now is they're reaching out to as many people as they can and haven't gotten to some of the Milligan plaintiffs. I think this is a decision that you do have to weigh when you're joining one of these cases. The risk and reward of all of this. If you have a stronger case, I think it's a better move to join one of these cases than somebody who is approved in April. But I can't say definitively that you're absolutely going to have an interview by June or anything like that by joining the London case. We've seen strong success kind of across the board for these mandamuses, so we're pretty confident. But it is an individual decision and something that you do have to weigh when joining.
Okay, that was the final question that we have. Any closing comments?
No, thanks all for joining us, and we will be back next week, same time, same place.
Thanks all.
Thank you.
Thank you.